litigation as a means to meet the goals and objectives of our clients.
It is May 27th, 2020. The mayor of the City of New York just signed into law a new ordinance that will enable commercial tenants who sign personal guarantees securing their rent and additional rent payments some reprieve as a result of the government response to the COVID-19 pandemic. This is an extraordinary turn of events. Both commercial landlords and businesses in the city have been struggling for the last several months as a result of the shutdown of non-essential businesses in the city. As a result, many commercial tenants don't have money to pay their rent, and many commercial landlords don't have money to pay their mortgages. What we have here with the enactment of this new ordinance in the City of New York is more of a benefit to the commercial tenants than it will be to the landlords. There should be some other enactments or government response with respect to helping the commercial landlords through this very difficult time. But this is very centered and is designed to help commercial tenants survive this pause. Now the city is starting to reopen, so we're going to be seeing some more revenues coming to these businesses. But in any event, this is a big occurrence in the city, and you should know about this. So what we know from commercial leasing is that many of the leases are secured by personal guarantees of the owners of the businesses. For those of you who don't know what a personal guarantee is, it is basically an owner of the business, shareholder or member of the business, or some non-related third party who puts their personal assets on the line to secure the performance of payment obligations under the commercial lease. Your business may be going under, and the corporation or the company may be hemorrhaging and insecure in its current financial status. However, as long as that personal guarantee remains in effect, the individual assets of that person who signed that guarantee is there to stand in line to pay the landlord whatever money the commercial tenant business owes, period. Under ordinary economic times, I'm very weary of these guarantees, but they sort of are a matter of course in Manhattan leasing, but also in the outer boroughs as well, and in the counties, the lower counties in the Hudson Valley and Long Island. But especially in light of the pandemic and the government requirement that businesses close, now these provisions are coming to the forefront, because it's bad enough for the commercial tenant that their business may be going under and losing money. But imagine now that business owner who signed that personal guarantee, who has a house in their own name, bank accounts in their own name, or other businesses in their name, or shares or member interests in other companies in their own name. Now those assets are there to pay the landlord money that's owed. So what happened now changes this in the interim. Let's take a look at the local law that was just enacted. This provision adds a new definition code in Section 1, Chapter 10 of Title 22 of the Administrative Code, blah, blah, blah. But where we get to the meat of this matter is where we actually have an amendment of Section 22-902 of the Administrative Code of the City of New York. And this deals with commercial tenant harassment. And as we scroll down into this new law, we will see where the changes were made. It is now deemed harassment of a commercial tenant where the landlord threatens to or implements a personal liability provision that is not enforceable pursuant to Section 22-1004 of the Code during the COVID-19 period, which means from March 7th of 2020 through the later occurrence of September 30th of 2020, or the government lifting the mandatory closure of business, whichever date is longer. What this means is that it will now be an act of tenant harassment for a landlord to enforce or seek to enforce against the personal guarantors of the commercial lease any monies that have accrued to the tenant from March 7th of 2020 through September 30th of 2020, or beyond the expiration of any extension of the moratorium listed in subsection little I or little II in this provision, whichever date is longer. Now we go through a whole set of people who are affected by COVID-19 that will benefit from this reprieve. And here we have Section 8, which are the person's business is closed as a direct result of the COVID-19 state disaster emergency. Or, and this paragraph was amended to include subdivision C, or a business that is impacted by COVID-19 if it was subject to seating, occupancy, or on-premises service limitations pursuant to an executive order issued by the governor or the mayor during the COVID-19 period, or if its revenues during any 3-month period within the COVID-19 period were less than 50% of its revenues for the same period in 2019, or less than 50% of its aggregate revenues for the months of December 19th, January 19th, and February 20th. Now, this is a very broad provision. If you Google some of the laws some of the headlines in some of the prior versions of the law, they really wanted to be sure that they addressed the barbershops, the bars, the restaurants, the movie theaters, the bowling alleys, and any other non-essential business that was not able to carry out its business as a result of the government shutdown. We ended up with this pretty broad language. If it was subject to seating, occupancy, or on-premises service limitations pursuant to executive order. So that very broad language here is intended to, and does in fact, and will encompass any business that, we're talking retail shops, that had to close down as a result of the governor or mayor executive orders that required these non-essential businesses to close. So that personal guarantee that you signed, the hardships that you suffered during the COVID period, those monies are going to be excluded. Looking at the remedies available under the city code to guarantors who are the victims of commercial tenant harassment are set forth further down in the regulations. And it provides that a commercial tenant may bring an action in any court of competent jurisdiction for a claim of commercial tenant harassment. If they find that the landlord engaged in harassment, the court can impose a civil penalty of not less than $10,000, no more than $50,000 for each covered property. Now, on its face, for some of the bigger commercial tenants, $50,000 is not quite going to go far enough when you're looking at arrears in the amount of, $300,000, $400,000 that have accrued over the last several months. But don't fret, because further down here at subdivision 3, the court can also award such other relief as it deems appropriate, including but not limited to injunctive relief, equitable relief, compensatory damages, punitive damages, and reasonable attorney's fees and court costs. So when all is said and done, that $50,000 cap looks a lot scarier to the landlord when you take into consideration this other sundry of horrible remedies that could be levied against them by the court. And this doesn't even limit to these remedies. There may be other remedies out there that a litigant may seek to impose. So The one important thing you do have to note is that this is not an excuse for the commercial tenant not to pay rent. Clearly, the bill will come due at some point in time, whether it's October, November, December, or January of 2021. This is not a complete get-out-of-jail-free card. However, this is one way that the government has put itself into these private contracts to protect the commercial tenants. Again, this is very much pro-commercial tenant because it lets the good guy, it lets the guarantor of the lease escape some liability as a result of them, the government, shutting you down. The commercial landlords will have to look elsewhere for some help, and hopefully that help will be coming. Stay safe out there. The city is starting to reopen. What terrific news for all of you commercial tenants, and what great news for all of you commercial landlords. We're all going to be cash flow positive pretty soon, but make sure if you're a commercial landlord that you don't start going after the good guy or the personal guarantor for monies that accrued during the COVID period of time. If you found this information useful and you think that you may benefit from other similar type information in the future, please hit the subscribe button, share this video with your friends, and make sure you stay safe out there, and we'll see you in the neighborhood pretty soon.